LLC. Connecting to the cloud.
It's connecting.
Is it overcast or what?
Thunderstorms coming.
Yay. Good evening, everyone. Welcome to the July meeting of the Inland Wetlands Watercourse Commission meeting. Sorry for starting so late. First up is audience of citizens. Anybody here who wants to say anything about any it's not on the agenda? If not, guys, minutes, look them over. Any additions, corrections, deletions? If not, I'd like a motion to approve.
Make a motion to approve the May 7th minutes.
Can I have a second?
Second.
All in favor? And the regular meeting is application 24-05 WF proposal by Calco Construction and Development to construct a mixed-use development within regulated wetland and flood hazard zones on 466 Deming Road, 337 Berlin Turnpike, and 51 Worthington Ridge.
My name is Sarah Cascagliola. I'm a licensed PE from BL Companies, and I'll be presenting on behalf of the applicant. So what you're looking at here is the survey, which shows these three parcels. The Deming Road parcel is right here. The Berlin Turnpike parcel is a much larger parcel, and then the Worthington Ridge parcel is a little rear lot down here. There are two existing buildings on the site, which will both remain. This building will have a portion demolished to approximate where this indent is. But these two buildings will remain, and then we have a third building that is proposed as part of this project. A demo plan, but so this is the proposed site plan. So as mentioned before, this is building 1, building 2, and then building 3 is a proposed restaurant in this area of the site. The wetlands on the site are in the southeast corner. Pretty much everything flows from the northwest to the southeast on the site. So this is the wetland limit that I will trace with my finger. And the Mattabasset River is what you see in this far corner down here. Pretty much the reason for the wetlands, as well as the floodplain, which is this thick dash line at approximately elevation 37. And then the primary locations of our disturbance within the 50-foot buffer are just this area, which is due to some grading for the parking, as well as this far area, which is due to the stormwater outlets, just to meet existing grade. This is the proposed grading and drainage plan. So we have a couple different stormwater detention systems beneath the proposed parking lot. One is up here, one is in this parcel, one is under this driveway, and then one is to the rear of the site. But altogether, all of these systems are piped into one pipe network, which then discharges these two outlet points adjacent to the wetlands. They are all treated by hydrodynamic separators that have been sized, pipes have been sized with 25 year storm, and the system itself has been sized for the 2, 10, 25, and 100 year match flow. Infiltration is not proposed due to the proximity of the wetlands of the floodplain and groundwater that was encountered during investigations. As far as erosion control, the main construction entrance will be off of Deming Road, which is up here. We have silt sacks and all the catch basins. We have a few different materials stockpiles shown just to give some options during construction, as well as a double measure of erosion protection along the wetlands, which is straw bale back silt fence all along the wetlands. that is pretty much the summary of the site, so I'd be happy to answer any questions.
So the actual construction really isn't going to go into the wetlands at all.
There's a few areas,
But-
but it's not a large area.
Right.
Yeah, so
Is
it's
it the
just
wetland or the upland? review?
upland review.
Yeah.
There's no
Yeah.
actual disturbance.
Do you know that square footage of impact?
Not off the top of my head.
Doesn't seem to be very large though.
It's pretty small.
And where they are, the buildings are already there, so you're not doing any construction as far as building a building, right? It's just parking area.
One building.
One, yeah.
Yeah,
one
but that's nowhere near any wetlands, so.
Yeah, the biggest impacts even in this area is just to get the stormwater system in there and then repaving.
What types of soils do you primarily find?
And what's going into that building?
This one,
Yeah.
this is a restaurant.
What about the bigger one?
There's going to be some retail as well as warehouse uses. So this one will remain warehouse. This portion over here will remain a warehouse, and then retail in the front portion, which the tenants aren't buying.
Okay.
I was looking through this, and it states this in a couple places. Stormwater management has been designed to be in general conformance with the inland wetlands and watercourses regulations. So that doesn't say full conformance, it says general. Why, what is the qualification?
We never say exact just because we never need everything exact. For example, infiltration is generally recommended, but for this to be able to site, you can't do that because of the wetlands and the floodplain. So there's things like that.
Okay,
And really doesn't refer to the inland wetland regulations, it's more about the stormwater quality, since those are guidelines versus regulations.
and did you say there are separators on these stormwater? And what are they? Can you say it again and tell me?
Hydrodynamic separators.
And what does that do?
They basically treat the stormwater that's coming into those systems for total suspended solids.
Okay, so it lets them settle out and pure water gets to the wet.
And then those will be vacuumed up when they're maintained about every
And then I'm
6 months
gonna
to a year,
I'm
depending.
going to cite another thing in here that I didn't understand what it means. In addition, as mentioned previously in this report, the 2-year storm event has decreased but has not met the 50% reduction standard due to existing roof area discharge.
So there's a new manual, stormwater quality manual that just got released March this year. It's a brand new, which recommends reducing the 2-year peak flow to half the existing flow, which for this site is very difficult to do without infiltration, especially because of the existing buildings. So we reduce the 2-year peak flow from what it is today. We're just not reducing to half what it is today.
And how much are you reducing it? That was probably in that table in here. Right?
Yeah, it's in the table there.
So there's a new standard that says it's supposed to be reduced by half, but you're not meeting that.
Yeah.
And why is that okay?
It's more, it's not economically feasible for a site that has like such large existing and you can't infiltrate. Because reducing the 2-year further without infiltration would basically require an orifice that is so small that it would be prone to significant clogging. So it's not providing a benefit if this is clogged.
So this is a new guideline?
Yeah, it's not a regulation.
It's not a regulation. Okay.
And for a site of this size, it's
That's a state guideline?
yeah.
Okay.
For a site of this size, it's locally approvable by your commission.
Any other questions? Bill, anything? Jim, it says we could go to public hearing, but I mean, it doesn't seem like there's a lot of
Yeah,
impact on the site.
and keep in mind, typically the commission will go to public hearing for two reasons. One is if we have direct impacts on the wetlands, which there are no direct impacts. All the activities are in the upland review area, and they are minimal. The other item would be for public interest. If the commission feels there would be public interest, knowing this is in a commercial zone on the turnpike, there is no residential activity within 1,000 feet in every direction. So it's clearly up to the commission. This is not your typical case where you would go to public hearing at the public. But that's your decision.
We still have to wait 30 days for,
Yes,
so we have to table this and
you'd have to wait till next month.
We'd have to wait 15 days to even.
right. So, yeah, so either way, well, but if we have a public hearing, that means we got to extend it to another 30 days after that.
No,
If,
no.
no?
We could schedule a public hearing for next month.
And,
And, you know, if there were no issues,
and approve it.
significant comments that were raised to the commission, could certainly take an action then. Close the hearing and take an action.
It's a pretty visible site.
Well, it's up to you guys. If you guys
Yeah.
want to have a public hearing,
It's interesting.
Same day, so it's your call.
Yeah, I'd say let's go to public hearing.
I make a motion, we hold a public hearing on application 24-05WF.
can I have a second? All in favor?
Aye.
See you next, see you next month. I'm not sure what the date is. So
August 6th.
August 6th. Next, another business, notice of violations. Notice violation, lot 2, block 127, number 552 Deming Road. The property has been cited for non-permitted activities regarding the placement of materials and disturbances within both the floodplain and floodway and upland review area adjacent to the Mattabesset River.
No one here to speak on their behalf. It's, as far as an update to the commission on this site, I've had several conversations with the property owner. If you recall, he came in back in May, did not have a June meeting. At that time, the commission directed him, gave him two directives. One was to remove the materials that are placed within the floodway, the 70 by, don't hold me to dimensions, 30 by 30 foot, high piles of wood adjacent to the river, right along the river bank, along with some other materials. And the commission asked for an as-built survey to determine how much fill has been brought in within the floodplain on that site. The only correspondence or conversations I've had have been through emails with the property owner. He was looking and questioning whether or not to move the materials to another site, Christian Lane, because of some concerns that we've had from previous approvals on the site. I recommended at that point to avoid that site until we get further information that the site has been disturbed. And we requested the property owner to provide us with some information with the disturbances that have occurred there. We have not received the information from that property owner. Without getting that, with not getting that information, I've recommended to this property owner, to search out other sites. I haven't heard anything else from him since then. So what I would recommend the commission look into, and I can certainly work with Attorney Capola to put a notice on the land records identifying the fact that there is a violation on the property. And until such time that the violation is corrected, that notice would stay on the land records. And looking for a recommendation from the commission to move ahead and proceed with that type of direction.
Jim, is the property owner the owner of that, all that wood, or is that a
I
sub?
believe it's someone he's renting to, and perhaps I may misspeak, but my understanding is from a zoning standpoint, that the zoning department has concerns that that type of use is not allowed on the property in that zone.
Right.
So that's another issue. We've had discussions with this property owner regarding concerns with activities along the river dating back to, I want to say, September of 22. And he's just kind of, it's been very frustrating, let's put it that way, trying to get him to understand what he can do.
If nobody has any other questions or comments for Jim, I would suggest that we make a motion to Jim to proceed along with Jennifer to put a notice of violation on the property to go into the land records.
What happens after that, Jim?
Well, that'll essentially put a cloud on the title.
Yeah.
Which, may deter certain things from happening, on the parcel. And until the property owner complies with the regulations, that notice will stay there. Once they clear up the violations on the parcel.
So the hope is that provides some incentive to them to do something. But
Correct.
if it doesn't, we have to take another step, or
I would defer to, Attorney Capola on that,
yeah,
but essentially it'll sit there until
some violation will
something
sit
comes
there, existing violation remains.
I mean, typically, let's say if the property owners would take a loan out of the property, you're transferring the property, that cloud is going to be there. And
All right, well, yeah, I mean,
What about if somebody wanted to rent or lease part of the property? Would he be able to?
that I don't.
So, question, your office is making the recommendation to place a notice on the land records because your negotiations, if you will, with the property owner have just gone nowhere, or?
They've been very unresponsive.
Okay, so you're making this recommendation based on the unresponsiveness of the property owner?
Correct.
Where it is in a nutshell.
Would anybody like to make a recommendation to this effect?
yeah, I make a motion to have the notice of violation placed on the land records, and that the item remains on the agenda as a check-in over the next several months to see what further steps may be necessary.
And we will certainly.
Yeah, right? Does that
And the
make sense?
intent is to get it resolved
Right.
as soon as possible.
Another question, what is the,
We have a motion on. Can he?
Need a second.
We have a second. All in favor?
No, with discussion.
No, excuse me. Go, I'm sorry, your question.
what is the procedure for removing an NOV from land record?
It's similar to a release of a lien, same type of document.
Okay, subject obviously to the
To the
town's
commission's approval.
and you don't see any other recourse at this point.
I don't see the property owner here this evening.
So if the property owner had showed up, you would be making this recommendation.
I would like to hear what his plan was, but obviously we don't have a plan in front of us.
He was before us last month, right?
2 months.
2 months ago,
2
yeah.
months ago, so he showed up last
We weren't here last
We
month.
didn't have a meeting last month. And he's been notified the agendas were sent. So
We have a motion made, a second. Any other questions? If not, all in favor?
Aye.
Very good. Number 2, notice violation, 61 Still Meadow Lane. The property owner is being cited for encroachment into both the upland review area and the wetland areas within the property. This property had previously been cited for similar encroachments of a number of years ago. The subdivided property plot plan clearly indicates the restrictions that were placed on the parcel.
I can tell you that I've been working with the property owner, Mr. Beretta, We've had several conversations over the past couple of months. I've spoken to his land surveyor. He's putting a plan together. He's in the process of putting an as-built plan together. We talked about a restoration plan, creating not necessarily a buffer, but a vegetative barrier, along wet lines. So it's a hardscape that he knows at this point that, he's got to stay out of there per se with filling and improvements within the area. So, and Mr. Beretta came in and I met him on the way in this evening and explained to him that, I've had the conversations with both him and his engineer, and I would advise the commission. He's been very cooperative. I said, I'll update the commission. There's no need for you to have to sit through a meeting.
No action to be taken.
No, he's been very cooperative.
All right.
I wish all of them were like.
Anybody have any questions for Jim?
It's the fellow with the wood chips, right?
No.
No,
The wood chips is Caminoa,
that's another.
which is, I think, next. So if there's no other questions for Jim, then we can proceed to the next one.
Yep.
Notice, number 3, notice of violation at 285 Sulington Road. This office was notified of potential wetland and upland review area disturbance several weeks ago. It appears disturbance have occurred based upon recent visit to the site.
Yeah, and if you recall, we did receive an official complaint, a written complaint from a neighbor on Southington Road about activity that was occurring. They were placing wood chips on, off an embankment down into the wetlands. I believe some drainage work was getting started to the rear of the house, installing culverts in a wetland area. I spoke with Mr. Campanelli today. To be honest with the commission, both he and I have been away several times over the past couple of months. We played phone tag. He agreed, if you recall, at our last meeting in May, that he and I would meet on the site. I was going to try to give him some direction on how to resolve the matter without getting into a full-blown restoration plan. We are going to meet next week on the 11th on site. So again, we don't have a lot of results here, but as I say, we've been playing phone tag, but he has been cooperative. So hopefully we'll have an update for you and perhaps put it to rest during our August meeting.
That's all I have for the business.
Yeah, one more.
One more.
Two more.
Two more.
Yeah.
I don't have that much. I must have left it at home. Right, thank you. Thank you. Number 4. Oh boy. Notice violation, Old Brickyard Lane.
Yeah, to update the commission on this one. If you recall, the commission and both the property owner and abutting property owner with the violation occurred, agreed to a restoration plan, and I just, it's more of a sketch, which I have in front of you this evening. There were a number of conditions that occurred with the resolution per se of the situation. We're trying to resolve it. We requested a certain seed mixture to be planted. I requested tags from the bags. It was a wetland seed mix. Back in probably first part of May, maybe the end of April, no, first part of May, I received a copy of an 8.5 by 11 of more of like an invoice of the seed mixture, wetland seed mixture that was placed on the site. I didn't receive the tags, but it's, it's taken some time to take off, but the vegetation that's there is weedy, and with various types of growth. So I'm assuming that mixture was placed accordingly. If you recall, there was a deadline on the planting of there's a note on the upper left-hand corner of the sketch of trees and some flowering shrubs that would be placed with location shown on the sketch. The deadline for that work was to occur by the 15th of June. And prior to the planting of the materials, the applicant or the property owner was to notify me so I could inspect them to make sure that they were what's shown, on the sketch. The 15th of June went by. Shortly thereafter, I received an email from the abutting property owner whose parcel was disturbed, saying, 15th's gone by, what's going on? Visited the site to confirm, and plantings were not in place. The vegetation was started. I've been visiting the site every couple of days since then. There was give you a little side scenario, but it still plays into it. The property owner, the violator, was looking to modify a site plan approval on the parcel adjacent to the parcel that was disturbed, and not seeing any action, by that deadline. I made a recommendation to the Planning and Zoning Commission with their modified site plan that, I would not sign off from the Public Works / Wetlands Department until such time as the restoration plan was complete, because obviously it didn't apply. There was some discussion on that. And I want to say that was last Thursday, I believe, Planning and Zoning. They approved it with the condition. We received an email after the close of work on Friday. Lisa had sent the property owner a copy of the agenda. The email came in saying that, oh, there's no need for me to come to the meeting because I finished the plan. I finished the work. I went out to the site on Monday. I've been out there a couple of times. Went out to the site on Monday, and plantings are in place. I checked the tags to see. Obviously, I didn't receive a phone call in advance. I checked the tags on what had been planted. The flowering shrubs are not what is listed here, but in doing a little research, and I'm not a horticulturist, but from my research, the flowering shrubs are in the same family, and so it's close. The 8 Austrian pines that are supposed to be 6 to 8 feet are not there. What is there are 2.5 to 3 foot Japanese black pines, and one of them is missing. There's only 7 of them. I couldn't find 8. Somebody wants to go out and take a look for themselves and count them. I tried to count them a few times. If I missed something, I missed something, but they're not there. We don't have 8 of them. So I do not know whether or not the abutting property owner whose property was disturbed is aware of the plantings that are in place, but the plan certainly has not been met at this point.
What is our recourse, Jim, as far as
The cloud.
We advised the violator that commission is not approving the plantings in place, and he agreed to plant those. They're not there, and
would that be something that Attorney Capola would have to do?
Jennifer, would you want to weigh in on that?
I am on. So your agent would send Jim would be the one to advise of non-compliance. If you wish to give an additional time to violator to remedy again this new non-compliance with the restoration plan that was approved, you could do so. And obviously, if there's continued non-compliance, there's the option to commence an action in Superior Court to attain compliance with what was approved.
My only problem, Jim, now I'm not an arborvitaeist, but now is not the time to be planting.
Typically, no. Now is not the time to be planting, or to plant personally.
Right.
You can certainly take a chance as a part of the, if you recall, as a part of the agreement in terms of the restoration. The plantings are to be guaranteed until June of 2025.
Right.
So you take a chance.
Well, so we don't know, for example, that this says 6 to 8 foot Austrian pines. They have 2 foot evergreens. We don't know if they're equivalent, or if they were 6 to 8 feet, we'd be happy with the species.
There may be one or two that are around 3 feet,
Yeah.
3.5, stretching it. The tags are still on every one of them out there. Some photos, so we know it's there. Bill, you had
Yeah.
you were going.
Yeah, I just want, so basically there's the wetland seed mix that got placed, that's okay. And then there were some flowering ornamentals that were not the right genus and species, but the right family. So that's okay.
That's my interpretation.
And but what you're having a problem with the shrub sapling layer, you're saying that called for 6 to 8 foot Austrian pines and
Japanese black pines.
black pine. And that's the problem.
Correct.
And
we're missing one.
Okay. And that's a problem because it didn't conform with the plan, but also is the height of the tree have some bearing on the function or the intent of the planting? Like 3 feet versus
8 feet, yes. And I believe the size of the plantings was to recreate that large vegetated buffer as quickly as possible.
So basically, it's the shrub layer that's not conforming.
Correct.
Do we need to make an action for
For you to
Issue a notice.
a notice of violation of non-conformant?
Yes. Yeah, if the commission makes a motion, right, recognizing the non-conformance with the restoration plan and direct the agent to notify the applicant and request the applicant appear, either correct the situation and or appear before the board to explain the reason why at our next meeting.
I mean, we're pretty sure that the complainant wouldn't be happy with what's been done.
Right, and that's why I asked you before, it's for us to even think about making a motion to approve this would be, it would be almost ready to hang us because they would come after
the right
us.
thing.
Yeah.
So I just want to point something out to you that, and I am looking at the actual, affirmation of the order that went out and the approval of the restoration plan. I want to note for you that part of the approval of the restoration plan, condition number 5 indicates to install the plantings as described and located on the sketch plan dated November 13, 2023, which sketch plan is incorporated and made part of the commission's decision. It says the wetlands agent shall confirm the type and size of plantings prior to installation, and plantings shall be installed by no later than June 15, 2024. And as Jim indicated, shall be warranted by 212 Old Brickyard Lane to survive through June 15th. 2025. So we have a couple of issues, right? You don't have the plantings in compliance with the plan that was proposed, that was incorporated into the decision. You have this issue of the responsible party, the violator, not seeking to confirm the type and size of the plantings prior to the installation. So that was ignored. And then you have the time frame being ignored because it indicates that it was to be done no later than June 15th. And then you have this warranty issue where, it indicates they're warranted by 212 Old Brickyard Lane to survive through June 15th, 2025. And so, that is going to need to be extended if it's a determination that you're, again, not satisfied because the plantings do not in fact comply with the plan. This, as the size is, I think part of the issue, Jim, too, is not the issue that the type of pine too is more susceptible to certain types of disease. Is that why you chose, I assume, the Austrian over?
Correct, correct.
So, yeah, so just for the record, to again memorialize those many issues. Now, in terms of the remaining conditions, so the wood chips, including the berm, have been removed from the disturbed area. Is that
Correct.
the case? Is the chain link fence in yet, or no?
No, it is not. No, it is not. And the property owner, the abutting property owner was going to install that on their,
No, I know that was going to occur through the better. How about the 4 parallel rows of erosion control straw wattles? Was that done at the top,
there
up
was,
to the slope?
there was only one row now down at the bottom.
Okay, so
So
that's an issue
they
of
were not.
non-compliance as well. I'm just, give me one moment. And in terms of the location of the plantings, they're not going to interfere with the installation of the fence, right? Because we have also the condition that the performance of the restoration work required by the preceding paragraphs 2 through 5 will be nothing will be located within 6 feet of the common property boundary to interfere.
I believe there will be an issue with 2 of the plantings.
Okay, so they need to be moved.
Yes. Yeah, I didn't have a tape measure with me when I went out, but I spoke with the property owner and he defined the boundary line for me. And from what I could see, I believe that they are going to be an issue.
And again, for the record, he was sent notice by the clerk of the agenda tonight and knew that, in fact, this matter was on, and he is not on Zoom and not physically present in the room.
No,
Okay. Okay.
anybody have anything else? Otherwise, make a motion to direct Jim to, he has a list of,
I'll work with Jennifer,
Yeah.
with Attorney Capola to structure the notice accordingly.
so can I have a motion to that effect?
Why is the land records tool not being used in this case?
We can certainly do that.
I mean, there's one thing to ignore us, to continue to come here and first be cagey and in my view disingenuous, and now to basically come up with a plan and completely ignore it, to be dishonest when saying he fully complied with the plan. I don't believe he's acting in good faith, and I think we should take at a minimum that step.
Correct me if I'm wrong, but my understanding, it's not the property owner who's the violator, it's the neighbor. Is that right?
Correct.
Yeah. So that's the problem.
No, we're talking about Mr. Kokumar.
Yeah, but he's not really isn't the property owner.
He's doing.
He's a violator because he went onto their property.
Jennifer, did you hear that question?
I'm sorry, I didn't quite hear the question. Could you repeat it, please?
Go, John.
No, I didn't have a comment about what sort of action we could take with the land records, but sounds like more of a private trespass issue.
So as far as land records are concerned, you know, the notice that did issue of decision, the letter of decision, it does reference the restoration plan being completed by 212 Old Brickyard, and you know, it references as well 245 Old Brickyard. So in terms of a recording of the letter of decision, that's something that we can certainly put on the land records. And, you know, it does, though, it's a very clear that to the extent that it would be also put on 245 Old Brickyard, that it is 212 Old Brickyard Lane that's in fact responsible for the majority of the work again, but for the installation of the chain link fence. So, you know, it would be fine, I think, if you're interested in recording the letter of decision, we could certainly do that. And then that once there's compliance, we would issue a notice just lifting the, you know, the cease and desist order that was affirmed through the approval of the restoration plan.
My only problem with that is now you're affecting the person who really didn't do anything, and this could stand. I mean, what we know about Mr. Kokomo is he had a tendency of, as we could see, of dragging things on. And is it going to negatively affect 245?
Yeah, can you put that notice only on the 212 land record and do nothing on 245?
I mean, we could do that. That I think that's, and you know, we could ask to have it recorded against whichever property. I mean, I think that's fine. I mean, again, you know, it's the notice provides an indication to anybody looking at the title, right, as to whether or not there's any particular issues. Somebody doing a full municipal search, you know, would go to Jim, you know, would go to Jim, would go to zoning to check, in fact, the records. This just kind of flags the fact that nonetheless that there's an issue on 245. I don't think that you know, it's necessarily something that's a negative for that property when the responsible party is being identified as 212 Old Brickyard Lane, not in fact the principal of 245. I think that the language in the beginning makes that very clear. But at the end of the day, I understand what your concern is, and I do think it's okay to direct the town clerk to only record against 212 Old Brickyard Lane. I think that's okay to do that as well. I would suggest again that the letter issue, because we have a situation where we're talking about swapping out plantings and so on and so forth. But before I think you make the decision to record anything, I think it makes good sense to issue the notice of noncompliance and encourage the violator to appear at your August meeting and address the commission with regard to the plan to bring his actions into compliance, and because it's likely that you may modify the order and the approval of the restoration plan. So I suggest you wait until that August meeting to make a decision on what gets recorded, because things may change in terms of you know, how things play out and expected actions.
Okay. So we need a motion to direct Jim, along with Attorney Capola, to send him a notice of violation of the plan, of the proposed plan.
Notice of non-conformance.
It's really notice of non-compliance, but that's
Right.
Same.
You first, second, all in favor?
Aye.
I made a motion to prepare a notice of non-conformance with the November 13th planting plan.
And John second.
Restoration plan.
The next one, number 5, 85 Meadow Lane.
Okay, Mr. Chairman, within your package, you received correspondence from the Land Trust expressing concern and looking for action to be taken as a result of the property owner number 85 Meadow Lane encroaching into what's referred to as some open space properties on the north side of Meadow Lane adjacent to number 85. That I believe they sent some photos. That's another one.
Yeah, I'm looking at this.
That's the next
This
one.
doesn't look like a
No.
Meadow Lane.
So the zoning department received the complaint. I've been working with zoning along with our staff in Public Works to determine just where the boundary lines are within that open space area. Our survey department went out and identified as best we could without doing an A2 survey of the boundary line on the property. And the clearing that essentially took place, and you have the plot plan in front of you.
Yeah.
The clearing that took place, all but one or two large trees, occurred actually within the parcel itself of number 85. It's deceiving because I think, in all due respect to the land trust, they were looking at the disturbance from the standpoint that there's a chain link fence installed along a portion of the westerly boundary in the front yard and side yard of 85. But the chain link fence is actually along the easterly side of the sewer easement that you'll see. It's a combination sewer and conservation easement. So they felt that the fence was the boundary, and they encroach much farther in. As I said, based upon our interpretation of the boundary, there may be one or two trees at the most. These were large trees.
Yeah, I know.
They were 60, 80-foot trees.
I saw them cutting them down, yeah.
Adjacent to the house. So there were probably one or two within a couple of feet of the boundary line. So I don't know how zoning is going to proceed. I don't see it as being an encroachment into the wetland area. I think if you look at the plan, there's a defined line of the floodplain itself, and then there is a block up top that talks about an area of regulated wetlands, but it's not identifying anything within this parcel, or even farther down. Yes, Belcher Brook is there. But my note, I'm interpreting the note on the plot plan is the area, surrounding the property. And you'll also note within note number 13 on the right-hand portion of the plot plan, it says no trees, shrubs, buildings, and/or obstructions shall be constructed and/or installed within the rights of way and/or easements as shown on the plan. So they're saying not to install any trees or shrubs.
Doesn't say they can't cut them down.
So I think, in all due respect, again, to the land trust, I think that they were basing their concerns based upon the chain link fence that was there. And everyone assumed at first that was the boundary, until Dave went out, tried to confirm where it was. It is what it is. And I'll contact Attorney Kern and advise him accordingly. Whether zoning is going to take any actions, I don't know, but I don't think you're going to see that. Bill.
Did the town speak with the property owner?
Yes, when the complaint first came in, I was actually away. The zoning department contacted the owner, said stop, and he stopped right off the bat. He didn't do another thing and hasn't done anything since then. So that's an update on that one. Okay, so last but not least, we received another piece of correspondence that I handed out this evening. We received it yesterday from the Land Trust regarding complaints that they have received in respect to filling of wetlands at number 3, I believe it's 389 Chamberlain Highway, 398. That's the former Johnson's Garden Center on the Chamberlain Highway. We were made aware of disturbances there probably this past late winter, early spring. Property owners come in and voice concern, as they have more particularly with the Planning and Zoning Department. There's a number of issues going on there with non-compliance, non-conformity of uses that were occurring. To make a long story short, we have a plan that dates back to, I want to say, the late 1990s, early 2000s, when the property was subdivided for a residential home on the north portion of the property. It showed a field-located wetland line on the parcel at that time. The parcel most recently was being used, as you probably all know, was a nursery. There were greenhouses and gardening going on. And as I explained to several of the budding property owners, when they were talking about the activities and what they felt were the wetland areas, that, you know, from an agricultural standpoint, there are certain uses that can occur within a wetland. For farming purposes, greenhouses, as long as something is not, you're not filling a wetland. Okay, you can go in and use it in its natural state. Grazing of cattle, things like that. I spoke to the property owner back, as I say, late winter, early spring, and said, listen, you know, we need some information on, you know, we're getting concerns expressed to fill the wetlands. We want to know what's going on. About to send a cease and desist out. And the comments came back, well, no, I'm looking at developing the property. I'm going to get a soil scientist. It's a scientist that's been before this commission on numerous occasions. He said he's going to be going out and flagging the wetlands. And that's the information that we would need if we sent out a notice of violation. So we have the 20-year-old wetland boundary now. We know where the new boundary is, and then we could take an action if we have to. I just can't go out there half-cocked and say, you know, you're filling the wetlands, and we need the proof. Long story short, 3-4 months later, I've had several discussions with the soil scientist. Yes, he did flag the area. It sounds like there are encroachments. The property owner advised us that he was coming in with a subdivision shortly with all that information on it. So I thought, well, that'd be the time we can say, okay, what happened? Things, again, just keep, maybe I give folks the benefit of the doubt too many times, but nothing has happened. And now that this official complaints come in from the land trust, I'd make a recommendation to the commission that you have your agent send out a cease and desist and request a show cause hearing be held at our next meeting on this property. And I'm hoping that will bring the current information at hand to light and before you, and we can move on from there in terms of, you know, how to correct the violation if it in fact has occurred.
Anybody have any questions? Would you like to, or would you like, yeah, go ahead.
So your inspection leads you to believe that the filling is recent?
Yes, within the past 6 months, 9 months.
Definitely recent.
Correct me if I'm wrong, going off the top of my head here, but yeah, there are exemptions for agricultural land use. My understanding is that those exemptions, the activities surrounding those exemptions needs to be explained to the town.
Yes.
I mean, it's something that's not automatically, well,
No.
doing agriculture, so
You have to advise us, yeah. In the previous site plan approval that occurred, and don't hold me to the date, late 90s, early 2000s, was for agricultural purposes. They were installing greenhouses.
I see.
That was after Johnson, right? That was,
Yeah, after Johnson.
was it,
Who was it?
yeah.
It was an offshoot of Sunny Border.
Sonny, but yeah, actually, I think it was Mark Laviana, his sons, yeah.
So with your permission or direction, I will send out a notice and we'll add one more to the list.
Can I have a motion to direct Jim to send out a notice of violation?
Make a motion to send out a notice of violation.
Can I have a second?
I'll second.
All in favor?
Aye.
You can have that back. I gotta find mine when I did it. Any other correspondence or anything, Jim?
I think as far as correspondence, we've gone through land trust, a couple of pieces of correspondence that we've discussed. So. No further correspondence.
If not, can I have a adjournment? Second?
Second.
All in favor?
Jennifer, we'll be in touch.
Very good. Thank you. Happy
Thank
4th.
you.
Jennifer and I have a trial together in 2 weeks. We're on the same side.
Oh, that's all.